Hi, I am Sophia. Welcome to True Payback, where story hits different. Hit subscribe. Let's dive in.
Millbrook, Ohio is the kind of town where everyone knows your business before you do. It sits 40 minutes east of Columbus on a road that used to carry factory workers and now mostly carries trucks. The downtown still has a hardware store, a diner called Patty's that opens at 5 in the morning, and a courthouse built in 1923 with the kind of marble floors that make every footstep sound like a verdict. I know those floors well now. I've walked them more times than I ever expected. My name is Claire Weston. I'm 34 years old. And for most of my life, my family treated me like a clerical error. Something that happened and couldn't be undone, but didn't need to be celebrated either. My parents, Gerald and Norma Weston, built their identity around my older brother, Derek. He was the athlete, the charmer, the one who filled the house with noise and laughter and made my parents feel like they had done something right. I was quieter. I read too much. I asked questions they found inconvenient. I didn't fit the version of daughter they had imagined, and they never quite forgave me for it. There's a specific kind of cruelty that only family can deliver. Strangers don't know where the bruises are. My parents knew exactly where mine were. In 4th grade, I won a regional mathematics competition. My mother's response was to ask whether I had remembered to send a thank you card to Derek's baseball coach. At my high school graduation, my father spent the reception telling other parents about Derek's college football scholarship. He mentioned my valedictorian speech once briefly as context for a joke about how I'd always talked too much. I stopped expecting acknowledgement somewhere around 16. I redirected the energy into work instead. My maternal grandmother, Ruth Calloway, was different. She saw what my parents didn't bother looking for. She came to my debate competitions. She kept a copy of my scholarship acceptance letter on her refrigerator for 3 years. When she visited and my parents made one of their dismissive comments, "Claire overthinks everything," or "she lives in her head," Grandma Ruth would look at me across the table with the smallest nod. The kind that says, "I see it. I see you." We were close in the way that skip-generation relationships often are. Honest. Unperformed. She never needed me to be the daughter my parents had wanted. She was interested in who I actually was. She used to sit at her kitchen table on Sunday afternoons with a legal pad, writing letters by hand to people she hadn't seen in years. She said email was fine for information but insufficient for feeling. I was 11 the first time she let me sit with her while she wrote. By 13, I was writing my own letters at the same table, drinking the instant coffee she made that was more milk than coffee, and she would read back sentences she liked and ask me what I thought of them. That was her version of mentorship. She didn't call it that. She just kept making space for me to think out loud and listen like what I said mattered and asked questions that assumed I was capable of answering them. Doesn't sound like much, maybe. But when you grow up in a house where your opinions are routinely treated as inconveniences, someone asking a real question and actually waiting for your answer feels like oxygen. When I was 26 and she was 81, Grandma Ruth was diagnosed with early-stage dementia. The progression was slow at first, then sudden, the way these things often are. I moved back to Millbrook for 8 months to help coordinate her care. I hired her nurses. I managed her finances. I drove her to every appointment. My parents visited twice in those 8 months. Derek visited once for a weekend and spent most of it on the phone. Grandma Ruth died on a Wednesday morning in March 4 years ago. She left behind a house on Birch Street, a savings account, 2 certificates of deposit, a small but solid stock portfolio, and a will she had drafted with her attorney 14 months before her diagnosis. She left everything to me. Total estate value, $3.7 million. I found out in the attorney's office. I sat very still while he read the will. I thought about the refrigerator with my scholarship letter on it. I thought about the nod across the table. I cried in my car afterward for a long time. Not because of the money. Because she had seen me when no one else had, and now she was gone, and the thing she left behind was proof of it. My parents found out about the will 3 days later. The attorney notified them as required. What happened next told me everything I needed to know about who they were. My mother called me the morning after she received the attorney's notification. I was in Columbus. I had gone back to my apartment and my work. And I answered because I still, despite everything, hoped she might surprise me. She did not. Ruth was confused, she said. Her voice was the one she used for things she had already decided. Flat. Finished. She hadn't been herself for years. You know that. Everyone knows that. A woman in her condition doesn't make sound decisions. She was diagnosed after the will was drafted, I said. The dates are documented. I'm not calling to argue about dates, Claire. What are you calling about? Silence. Then, your father and I are consulting with an attorney. I said I understood. I hung up and sat at my kitchen table for a long time without moving. I had expected something. I had not expected it to arrive this fast or feel this cold. The thing about being the family disappointment is that at some point, you stop being disappointed in yourself and start being disappointed in them. That morning, sitting in my kitchen with my phone face down on the table, I passed some kind of threshold. I stopped grieving the family I had hoped for and started preparing for the family I actually had. I called my own attorney the same afternoon. Her name is Margaret Osei. She runs a firm out of Columbus, sharp and methodical, the kind of lawyer who reads every footnote. I told her everything. She listened without interrupting, which I appreciated. They're going to challenge the testamentary capacity, she said when I finished. I know. Which means they'll argue your grandmother wasn't mentally competent when she drafted the will. I know that too. That's why I'm calling you. Margaret paused. I heard her click her pen. Tell me about the 14 months between when the will was drafted and when the diagnosis came. I told her about the care logs I had kept during those 8 months in Millbrook. I told her about Grandma Ruth's regular check-ins with her physician. I told her about the attorney who had drafted the will, a man named Samuel Greer, semi-retired, careful, who had practiced estate law in Columbus for 31 years. I told her that Samuel had included a recorded interview with Grandma Ruth during the drafting process, a practice he had adopted years earlier specifically to document client capacity. Margaret's pen stopped clicking. He has a recording of her competency interview? 47 minutes, I said. She discusses every asset, every decision, every reason. Another pause. Longer this time. Claire, she said, I need you to get me that recording. Already had it. Samuel had given me a copy the day of the will reading. He had pressed it into my hand before I left his office. A USB drive, small and unremarkable, and said quietly, keep this somewhere safe. I have a feeling you're going to need it. He had been right. Over the next 8 months, while my parents' attorney filed motions and sent letters and talked to local reporters about elder financial exploitation, I built my case the way I build everything. Quietly, systematically, without announcing what I was doing. I want to be specific about this because I think people imagine that responding to something like this is dramatic. It isn't. It's tedious. It's spreadsheets and phone calls and folders organized by date. It's reading legal filings at 11 at night and writing down questions for Margaret. It's being very careful for a very long time while on the other side of town people say things about you that aren't true and some people believe them. It's also, underneath all of that, grief. Because every document I pulled about Grandma Ruth's estate was a reminder that she was gone and that this was what remained of loving her. A legal dispute, a forensic audit, and a courtroom in October. I didn't have the luxury of processing that properly. I noted it, set it aside, and kept working. I commissioned a forensic accounting firm out of Cleveland to audit the estate records going back 15 years. I obtained Grandma Ruth's complete medical history from her physicians, all of whom confirmed her cognitive status at the time the will was drafted. I tracked down all 4 witnesses who had been present at the will signing. I documented every visit, every expense, every decision I had made during those 8 months of care. And I hired a forensic accountant named Daniel Marsh, who wore the same gray suit to every meeting and had a way of presenting numbers that made juries lean forward in their seats. I did not tell my parents what I was building. I did not respond to their attorney's press statements. I went to work, came home, called Margaret every Thursday morning and waited. The hearing was scheduled for a Tuesday in October at 9 in the morning. Millbrook County Courthouse. Courtroom B. The one with the stuck window on the west wall and the painting of a landscape that nobody could identify. I arrived at 8:15. I sat in my car in the parking lot for 10 minutes before going in. Not because I was scared. Because I knew that after today the word family would mean something different. I was making peace with that before I walked through the door. Then I picked up my briefcase, straightened my jacket, and went inside. Courtroom B was full by 9. I had been in this room once before years ago for a traffic matter that took 11 minutes. It had felt large and indifferent then, the kind of room that doesn't notice you. Today it felt different. Warmer, more crowded, and somehow smaller. The way rooms shrink when they contain something that matters. My parents had brought people. Cousins I recognized from holidays I barely remembered. My mother's friend Patricia, who had strong opinions about everything and sat in the second row like she was there to supervise. A few neighbors from Birch Street who had apparently decided this was worth their Tuesday morning. They had dressed for it. Not formally, exactly, but intentionally, the kind of clothes people wear when they want to communicate that they belong somewhere. Derek sat directly behind my parents. He had dressed for the occasion in a blazer that still had the crease from the hanger. He caught my eye when I walked in and looked away first. The judge was the Honorable William Faraday. 62 years old, appointed 12 years ago, served on the Bar Association committee that my father had chaired for 3 years. He had attended my parents' 30th anniversary party at the Millbrook Country Club last April, according to the photo I'd found on my mother's Facebook page, where Judge Faraday stood with his arm around my father and smiled for the camera. I had filed a motion for recusal 6 weeks earlier. It had been denied. Margaret had told me not to worry about it. Let him stay, she said. Judges who should have recused themselves and didn't are the most careful during the actual proceeding. They're watching their own behavior. I had trusted her then. Sitting in the courtroom now, watching Judge Faraday give my parents a courteous nod as he took his seat, I worked to keep trusting her. My parents' attorney was Richard Holloway. Mid-50s, silver-haired, the kind of lawyer who filled a room with certainty before he said a word. He had a good reputation in Millbrook, which in this context meant that people believed him before he was done talking. He stood at exactly 9:03. Your Honor, he said, adjusting his tie, the plaintiffs will demonstrate today that the defendant, Claire Weston, exerted undue influence over an elderly, cognitively compromised woman to secure a last-minute transfer of assets worth $3.7 million. We will further demonstrate that Ruth Calloway lacked testamentary capacity at the time the contested will was drafted, and that the defendant exploited a position of caretaker access to manipulate the decedent in the final vulnerable years of her life. He was smooth. I'll give him that. He spoke the words the way someone reads a menu, like they were obvious, like the answer was already known, like this was just the formality before the conclusion. My mother nodded from the plaintiff's table. She had worn gray. Good strategy. She looked understated and grieved. Judge Faraday wrote something on his notepad. He had not looked at me yet. I opened my briefcase. I did not make a speech. I did not stand dramatically. I simply lifted the case onto the table, unlatched it, and said 2 words. Your Honor. Daniel Marsh, seated to my left, stood on cue and placed 11 binders on the table. Organized by tab. Color-coded by category. Each one labeled in the top right corner with a case reference number. 11 binders stacked in 2 neat rows. The judge's pen stopped moving. Richard Holloway glanced at the binders. Then at me. His hand, which had been moving toward his own folders, went still. Margaret stood. Your Honor, the defense is prepared to present documented evidence regarding testamentary capacity, caretaker conduct, estate management, and additional findings that arose during the course of our forensic review. We would like to begin with Exhibit A. She slid a single document across to the court clerk. The clerk handed it to Judge Faraday. It was the first page of Daniel Marsh's forensic accounting report. 112 pages total. But the first page contained a summary table. Simple, clean, and specific. The judge read it for a moment. His expression did not change, but he turned to a second page when I would not have expected him to. Holloway asked to approach the bench. The judge waved him back. Let's hear from the defense first, Judge Faraday said. His voice was different now. More measured. Less comfortable. Margaret introduced Samuel Greer, who testified for 40 minutes about the drafting of the will, his capacity assessment process, and the 47-minute recorded interview. The recording was played in full. Courtroom B was absolutely silent while Grandma Ruth's voice filled the room. Clear. Precise. Thoughtful. She named every asset. She explained every decision. She spoke about me with a directness and specificity that made someone in the gallery make a sound they quickly suppressed. She spoke about my parents too. Carefully. Without malice. She said she loved them. She also said she had watched them for 60 years and she knew what they did with things that were given to them. She said that wasn't a judgment, just arithmetic, she told Samuel in the recording, and there was something almost fond in her voice. The kind of fondness that has made its peace with disappointment. The recording ran for 47 minutes. Nobody moved. Nobody checked their phone. Patricia, in the second row, had folded her hands in her lap. My mother's expression went from grief to something harder. Then Margaret introduced Dr. Patricia Hollis, the geriatric specialist who had reviewed Grandma Ruth's complete medical records. Dr. Hollis testified that at the time the will was drafted, Ruth Calloway showed no clinical indicators of cognitive impairment sufficient to affect her legal decision-making capacity. She cited 6 standardized assessments. She cited the physician's notes from 8 separate appointments in the year prior to the will. Then came Daniel Marsh. He was precise the way an actuary is precise. Not dramatic, not performative, just relentlessly factual. He walked through the estate records for 15 years. He documented every account, every transfer, every transaction. He had a way of presenting numbers that made the room lean slightly forward, not because he was performing but because the numbers themselves were doing something and people could feel it. He paused once, about 20 minutes into his testimony, to adjust the document on the easel beside him. The courtroom was silent during that pause in a way that courtrooms usually aren't. The kind of silence that arrives when people sense something is coming and aren't sure whether they want it to get there. Then he continued. He documented the transfers that the estate audit had uncovered during review. Specifically, a series of transactions between 2019 and 2022, totaling $312,000, from Ruth Calloway's secondary checking account to a business account registered to Derek Weston LLC. Documented in bank records. Time-stamped. These were not loans. There were no signed agreements. No repayment schedule. No documentation of any kind beyond the wire confirmations themselves. Under Ohio probate law, undocumented transfers from an estate beneficiary in the years preceding death carry specific legal implications. Daniel Marsh explained those implications in the same even tone he had used for everything else. The gallery had gone completely still. I heard Patricia exhale in the second row. A single breath. That was the only sound. Richard Holloway objected 3 times in 4 minutes. Judge Faraday overruled each one without much deliberation. The third overruling came before Holloway had finished stating the basis for the objection. The judge simply said "overruled," and looked back at Daniel Marsh. That was the moment I knew. My brother sat behind my parents with his blazer and his crease and his expression that had been slowly changing for the past 90 minutes. He was looking at the table now. Not at me. Not at the judge. At the table. My mother turned once to look at me. Just once, and only for a second. Her expression wasn't grief anymore. It wasn't anger either. It was something I had seen rarely enough in my life that it took me a moment to place it. She was frightened. I looked back at her evenly. I didn't smile. I didn't look away. I just held her gaze until she turned back around. Margaret then introduced Exhibit K, the sworn statements from all 4 witnesses at the will signing, and Exhibit L, my complete care log from the 8 months I had spent in Millbrook. Every appointment, every nurse's schedule, every grocery receipt, every prescription pickup. 214 entries over 31 weeks. Judge Faraday read the cover page of Exhibit L and then looked at Richard Holloway. "Counselor," he said, "does the plaintiff have documentation of their own care contributions during this period?" Richard Holloway said that the plaintiffs would address that in their presentation. Judge Faraday said he looked forward to it. His tone suggested otherwise. They recessed at noon for 45 minutes. I ate a sandwich at the table in the small conference room Margaret had reserved. I wasn't hungry, but she had told me to eat, so I did. She sat across from me reviewing notes. Daniel Marsh was on his phone in the corner. The room smelled like coffee from a machine in the hallway and something vaguely institutional, carpet and old paper and the particular neutral smell of rooms where things are decided. "How do you think it's going?" I asked her. She looked up. "I think the judge is doing arithmetic." I nodded. I took another bite of the sandwich. It was turkey from the deli 2 blocks from the courthouse, where the woman behind the counter had told me I looked like I was having a hard day and added extra mustard without asking. Small kindness. I had almost cried about it in the parking lot, which surprised me. 8 months of preparation and I almost came apart over mustard. Grief does that. It hides in the margins and waits for unguarded moments. When we returned to courtroom B, Richard Holloway's presentation lasted 22 minutes. He produced 3 documents. A signed statement from my mother about her emotional relationship with Ruth Calloway, a letter from a neighbor who said she had concerns about my presence in Millbrook during those months, and a printed summary of the dementia diagnosis date, which, as I had told my mother on the phone 8 months earlier, post-dated the will by 14 months. He did not produce caretaker documentation, because there was none. He did not address the $312,000 in transfers. He hadn't known about them until this morning. Judge Faraday asked Holloway 3 questions. The first was about the evidentiary basis for the undue influence claim. The second was about the timeline discrepancy between the will and the diagnosis. The third was about the transfers. Holloway's answer to the third question was that his clients were not currently parties to any financial dispute regarding those transfers, and that the matter was outside the scope of the current proceeding. Judge Faraday considered this for a moment. Then he picked up his pen. He ruled from the bench. He did not take it under advisement. He did not schedule further proceedings. He ruled that afternoon in courtroom B, while the sun came through the stuck window at a low October angle and made the unidentifiable landscape painting look almost warm. The will was valid. Ruth Calloway had demonstrated full testamentary capacity at the time of its drafting. The evidence for undue influence was not merely insufficient. It was, in the judge's phrasing, contradicted by the documented record at every significant point. He awarded me legal costs. He referred the matter of the $312,000 in undocumented transfers to the county prosecutor's office for review. And then he looked up from his notepad directly at my parents' table and said something I did not expect. His voice was quiet, almost gentle. "I want to be clear," he said, "that the court is not in the business of judging family relationships. But the record in this case contains documentation of genuine care and genuine generosity on the part of the defendant toward the decedent, and a near total absence of the same from the plaintiffs. Whatever brought this case to my courtroom today, I hope everyone here will think carefully about what that record says." Richard Holloway gathered his folders. His assistant, a young woman who had been efficient and serious all morning, would not look at the plaintiff's table. My parents stood slowly. My mother's hand was on the table, steadying herself. Derek left before anyone else. He was out the side door before the judge had finished speaking. I heard his footsteps on the marble, quick, uneven, and then nothing. I sat in the parking lot again. Same spot as the morning. Different feeling. Margaret had offered to take me to dinner. I had said I needed an hour. She had nodded. She was good at knowing when to give people space, and gone back inside to finalize paperwork. I sat with the engine off and the windows up, in the October cold that was already starting to come in around the edges of the car door. I thought about Grandma Ruth's voice on that recording, filling the silent courtroom. 31 people listening to a woman explain why she had made the choices she made. Why she had trusted me. On the drive home, I didn't feel victorious. I felt something I couldn't name. Like winning a war in a country you used to love. Money doesn't fix a family. But it does change who's asking for favors. My father called 4 days later. I let it go to voicemail. He left a message that was 40 seconds long and said he thought we should talk. He used the word misunderstanding twice. He did not mention the $312,000. I did not call back. My mother texted the following week. I read it and put my phone down. In the months that followed, I learned through Margaret that the county prosecutor had opened a preliminary inquiry into the transfers. Derek retained his own attorney. The matter was ongoing as of the time I'm telling this story. The estate has been settled. Grandma Ruth's house on Birch Street has been sold to a young couple who have already painted the front porch. I drove past it last spring and felt something complicated. Not sad exactly. Not resolved either. Just complicated in the way that things involving people you love tend to be. I kept the scholarship letter. My mother had a copy in a box somewhere, but the original had been in Grandma Ruth's kitchen drawer. The attorney found it when we were clearing the house and sent it to me. It's in my apartment now. Same place it's always been now that I think about it. I'm not saying the door is closed forever. I'm saying the terms have changed and I don't set them alone anymore. If my parents want a relationship with me, they'll need to start with honesty. Real honesty. The kind that doesn't arrive after a legal ruling and immediately pivot to damage control. I learned something about apologies. The ones that come after you have power aren't really apologies. They're negotiations. Grandma Ruth knew who I was when no one else was paying attention. She didn't need a courtroom to tell her. She didn't need a reversal or a revelation or 11 binders to make her decision. She just watched and listened and wrote it down with Samuel Greer on a Wednesday afternoon 14 months before anyone thought it would matter. I think about that a lot. The quiet things that turn out to matter. The nods across tables. The scholarship letters kept on refrigerators. The recordings that wait in a drawer for the day someone tries to say the truth didn't happen. It happened. All of it. And I have documentation. If you've ever been the person in your family who was overlooked, dismissed, or had to fight just to be believed, this one was for you. Drop a comment and tell me where you're watching from. I read every single one. Like and subscribe if this story stayed with you. New stories every week.